Hello again, Colin Manning here. This is our final look at the GDPR. The first thing we're going to look at very briefly is the supervisory authorities that are responsible for the enforcement of the GDPR throughout the EU. And then we're also going to look at the remedies, liability and penalties. So the remedies open to data subjects, the liability for any infringements of the regulation, and the penalties that might be applied to those infringers. First up though, let's just talk briefly about the independent supervisory authorities. The first thing we need to note about the supervisory authorities is that it's authorities. There's more than one. So when the GDPR was being drafted in order to replace the Data Protection Directive, one of the big questions was, would there be a single supervisory authority that would be responsible for the enforcement of the GDPR throughout the whole EU? Or would the enforcement be more local and perhaps be at the member state level? And there was a lot of toing and froing. Under the Data Protection Directive, the enforcement was at the member state level or even lower. So all of the data protection issues for people in Ireland were supervised by the Office of the Data Protection Commissioner in Ireland. And the big question was, would this continue? Would the Data Protection Officer in Ireland have that competence still for Ireland? Or would it be at a higher level and regulated for the whole of the EU by a separate agency in Brussels or Berlin or wherever? In the end, they went for the supervisory authorities. So the Office of the Data Protection Commissioner in Ireland is still responsible for enforcement in Ireland. But of course, a big issue was, how do you deal with big companies like Google and Facebook and Apple that operate throughout the EU? And how do you deal with multinational operations that are operating in several member states and have customers in many member states? How does that all work out? So the way it works now is that the supervisory authority responsible for the place where the organisation is headquartered regulates all of its activities throughout the EU. And if an organisation, if a data controller has satisfied the supervisory authority of the member state where it is, well then that's good enough for all of the other member states. So Google operates out of Dublin, and so it answers to the Data Protection Commissioner in Ireland. The same applies to Facebook. Facebook operates out of Dublin, which is why, for example, the age at which children can give their consent to sign up to Facebook is 13, because Ireland, the member state from where it's regulated, decided that it would go for 13 rather than the default 16. This has led to some controversy and some differences of opinion. It's fair to say that different countries take perhaps slightly different approaches to data protection and that they have different sensitivities. So people in the UK, for example, have always been very opposed to the introduction of ID cards. The introduction of ID cards in Ireland didn't happen either, whereas in other countries it's not a big deal. Some countries are very strict about national identifiers. In Ireland, there are only very specific circumstances under which you can even ask for someone's PPS number, let alone use it. Whereas in Spain, you would use your ID number even when you're booking a bus ticket or subscribing to a magazine. When someone delivers a package to your door, they ask you for the equivalent of your PPS number and take note of it. In Ireland, that wouldn't happen at all. And it is fair to say that for quite reasonable historical reasons, Germans are particularly sensitive to the mass collection of data and particularly sensitive about the collection of data relating to ethnicity or to religion. People in France are very sensitive to the collection of data about religion or ethnicity. If you wanted to know how many Jewish people are living in France, for example, you can't know because no one would dare even collect that kind of information. And of course, for historical reasons, that's not a huge shock. That sensitivity is quite understandable. Although Europeans' sensitivities to data collection is often attributed to countries' experiences under the Third Reich, it's worth remembering that after the Second World War, East Germany was a very oppressive place for many decades, and the East German state engaged in a systematic mass surveillance of its citizens. And so the living memory of that experience and the more historical memory of the Third Reich make Germans, for example, super sensitive to data collection. In Ireland, of course, the Germans did not invade. We didn't have a communist dictatorship. And there's a general skepticism about government, but also we haven't really suffered under terribly oppressive governments for at least 100 years. So it's easy to speculate, for example, why Irish people might be, although perfectly prepared to comply with the letter of the GDPR, are culturally, at least, a bit more relaxed about data processing than, say, their German cousins. And so there are inevitable differences of approach, shall we say, and different sensitivities abound. So one of the things then that people like to complain about Ireland, in addition to the way Ireland taxes big corporations, is the extent to which it thoroughly enforces data protection rules. And it is often suggested, rightly or wrongly, that Ireland isn't that serious about it. Now, of course, Ireland has the good fortune to be home to Google and Facebook and to be responsible for regulating Google and Facebook. And of course, that's a massive task. That's a task that would challenge any supervisory authority. But it is arguable that the supervisory authority in Ireland could perhaps be better resourced. The Data Protection Commissioner now has an office in Dublin city centre. But for many, many years, the regulation of Google and Facebook and Apple was conducted out of the only office, which is in Portarlington. And we can see here on a screenshot from Google Maps that it's next to a spar on Canal Street in Portarlington. Now, there's nothing wrong with Portarlington. I've never been to Portarlington, but I'm sure it's a lovely place. And as a Cork man, of course, I could never subscribe to the notion that you can only do decent work if you're in Dublin. But it is fair to say that someone looking at this would ask why the office responsible for regulating Google and Facebook is next to the spar in Portarlington. It did raise quite a few eyebrows that the office didn't have a presence in Dublin. It does now, and I'm sure that helps with the regulation of the big companies that are down the road. Now, there's a whole bunch of articles in the GDPR about the supervisory authorities and their role and what they do. I don't think we need to consider those. And there are also articles on the cooperation between the supervisory authorities and provisions to ensure that they interpret the GDPR consistently. And there is a supervisor of the supervisory authorities also that has a coordinating function and sort of regulates them to some extent. But that, again, is quite a meta concern that as potential data controllers or data processors or data protection officers doesn't concern us in particular. What does concern us are the remedies, liability and penalties set out in Chapter 8 of the GDPR. So the GDPR provides for more serious enforcement and penalties than the Data Protection Directive did. It even provides for compensation for data subjects and fines for data controllers. So if you are a data subject and you are unhappy with the way your data has been processed by a data controller, you have the right to complain. So first up, in Article 77, you have the right to lodge a complaint with the supervisory authority. So wherever you live in Europe, there will be a supervisory authority for that region, and you have the right to complain to that supervisory authority, which will then investigate your complaint and see it through. So if you are in Germany and you have an issue with Facebook, you can apply to the supervisory authority for your land, and that supervisory authority will take that on. That might require some liaison with the supervisory authority for Ireland, where Facebook is, but that's not the concern of the data subject that's filed the complaint. Now, in addition to filing a complaint with the supervisory authority, there are other remedies and other options available. In Article 78, there's a very interesting right that the data subject has, and that's the right to an effective judicial remedy against the supervisory authority. So if you're not happy with the way the supervisory authority is doing its job in relation to your personal data, you can go to court. You can also take the controller or processor to court, and you can do that directly and exercise your rights directly without going through the supervisory authority. So Article 82 of the GDPR points out that the data subject has a right to compensation. Anyone who has suffered material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor. Any controller involved in processing shall be liable for the damages. Now, it's the controller that is on the hook. It's the controller that has the liability. The processor is only liable insofar as the processor took on things it wasn't supposed to do. But if the processor is following the instructions of the controller, it's the controller that has the problem. So a processor shall be liable for the damage caused by processing only where it has not complied with the obligations of this regulation, or where it has acted outside or contrary to lawful instructions of the controller. A controller or processor shall be exempt from liability if it proves that it is not in any way responsible for the event giving rise to the damage. So those are rights that the data subject has to go to court and get compensation from the data controller. However, the supervisory authority also has a role in enforcement, and the supervisory authority can impose fines. And these fines can be quite significant. Now, the calculation then of the fine is set out in 83.2, and the size of the fine will depend on a number of factors. And these include the nature, gravity and duration of the infringement, as well as the number of data subjects affected and the level of damage suffered by them. So if 10 people suffer a little bit of damage, that's one thing. If 100,000 people suffer a lot of damage, or 10 million people suffer a lot of damage, that's a whole other thing. Also considered is the intentional or negligent character of the infringement. So if it was deliberate or sloppy. Any actions taken by the controller or processor to mitigate the damage, so that can count in your favour. The degree of responsibility of the controller or processor, taking into account technical and organisational measures implemented by them. Now, as we've seen, the GDPR doesn't specify any specific standards or any specific technical measures. It's quite elastic. You're supposed to do whatever sort of the best practice is at the time. Now, if you've been doing best practice and it turns out that North Korean or Russian hackers infiltrate your system, well, that's a very different thing than if you were just sloppy and some young fella in Cahersiveen, guessed the password. Like, there are levels of culpability. There are best practices that can be implemented, And if you're doing those, then you know you're on good ground. Interestingly, in Part E, we have relevant previous infringements by the controller or processor. So if this isn't your first time, the fines can be much higher the second time. The degree of cooperation with the supervisory authority is an important factor. So if you fess up and if you cooperate, that can count in your favour. But if you act the bollocks and stall and try to hide what happened, that can count against you. The categories of personal data affected by the infringement. So the nature of the data that's infringed can make things better or worse. If it's very sensitive data or very personal data, that's more serious than regular data. The manner in which the infringement became known to the supervisory authority is important. If the supervisory authority hears about the data breach in the paper and you haven't reported it, well, that's a big problem. If the supervisory authority hears about it from a data subject who has been complaining to the data controller for some time and getting nowhere, then that's a big problem. Now, in 83.2, we see that where measures have been previously ordered, compliance with those measures is required. If they haven't been complied with, well, you know, that's a big issue. That's going to make things a lot worse. If the data controller has adhered to a code of conduct, so if the data controller has done everything by the book and something bad happened, well, that's different than if the data controller was deviating from the code of conduct that had signed up to. And then be any aggravating or mitigating factors. A big thing really is the scale of the breach and the scale of the problem. So companies like Twitter and Google and Facebook that might have millions and millions of records can be facing into fairly massive fines if there's a big data breach. In Article 83.4, we see that the GDPR is quite specific about the range of fines. So the fine can be up to 10 million euro or up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is the higher. So for people for whom 10 million euro isn't a lot of money, it can be 2% of total worldwide annual turnover, not just even the turnover in the EU. Facebook, for example, could be facing a fine of 2% of its total worldwide turnover. I keep repeating myself, but that is a lot. And that's where obligations under Articles 8, 11, 25, 39, 42 and 43 have been infringed. 8 is processing data on children. Article 11 is the one about processing data that no longer requires identification. 25 is data protection by design and by default. And 42 and 43 are to do with certification. Now, if you're thinking infringement of those articles don't seem like the worst thing you could do, you'd be right. These are the lesser sins. In Article 83.5, we see that infringement of other articles has double the penalty. So the controller can be fined 20 million euro or up to 4% of the total annual turnover. And so that can happen where the principles for processing, including conditions for consent pursuant to Articles 5, 6, 7 and 9 are infringed. Article 5 is the general principles. Article 6 is the lawfulness of the processing. Article 7 is all about consent. And Article 9 is the one that deals with the special categories of personal data. So infringe on any of those and it's double the penalty for the other ones. The Articles 12 through 22 deal with the data subject's rights. So those would be access rights, rectification rights, all of those in there. Infringe those. Those are the bigger sins. If the transfers of personal data to a third country aren't up to scratch, That's in there too. There may be obligations under member state law that the data controller is required to abide by. And if those are infringed, we're in the big league as well. And of course, where the supervisory authority has specifically told you to stop doing something and you keep doing it, you're in big trouble too. In summary then, enforcement of the GDPR is up to the relevant supervisory authority. And that can be at the member state level or even at smaller levels in federal systems. And the data subject, if they have a problem, can complain to the supervisory authority about the data controller. The data subject may also exercise his or her rights directly by going to court and suing the data controller. However, the supervisory authority can also investigate and then penalise the data controller with fines. And as we've seen, those fines can be pretty hefty. We're still in the early days of the GDPR, but there are some big headline cases with big fines being reported in the press already.